Hi, my name is Abigail Seymour. I am an attorney in Greensboro, North Carolina, and I practice family law, particularly custody. And a question that comes up a lot is whether or not a person needs to have a custody order once they have separated, and the answer is no. If you are getting along fine with your partner and you guys have figured out how you'd like to handle custody between the two of you, then you can just have a verbal agreement or even something written on the back of a napkin. It should be fine. The issue is whether or not you are, if there's a conflict about where and how you want to arrange your schedule with regard to the children. And the way the law is written is actually meant to try and detour you to work it out yourselves through mediation rather than go to court. So I think the fantasy of getting your day in court and letting a judge decide is not really realistic and not really the best thing for your kids and for you guys. That is there for you always if you really can't work it out, but there are lots of ways along during the process to find a way to settle. You can negotiate agreement between the two of you during mediation. You can come to an agreement afterwards through your attorney and even through yourselves again, if you go back to the mediator so they can have it signed by a judge. It has to be inside the court process, though. You can't just come to an agreement. There has to be a complaint and an underlying case in order to finalize an agreement. And that can also come through a judge. So if really you can't get there, you can go in front of the judge. And the way that's decided is really based on the best interest of the child. So there are lots of different ways the court looks at that. And a lot of judges really do want to weigh in. The way the law is written, again, is that it should be equitable. It doesn't say equal, but equitable. So 50-50 is the way a lot of judges are going to want to come down, and there's a lot of studies showing, of course, that it's better for the children to have access to both parents on an equal basis. And so, so bottom line, you don't need an order, but it does help you if things were to go south, so to speak, and one of you is deciding the other one shouldn't have the kids, or one of you's decided they're going to move to another country or go to a state that's far away, or doesn't want to share information about the kid's doctors or a therapist or any kinds of things that you both legally have the right to have access to as the parent, and the other person is withholding that, then that's where the order comes in order to enforce those types of things. So anyway, so if that's something you need help with, that's what we do. That's what my office does at Camino Law, and we're happy to help and really do try to help people negotiate something if possible. I like to say that we like to try to keep families out of court and try to help you guys stay friends, but absolutely we can go one way, we can go that way, or we can go to court if you need to and help you navigate that process as well. So give a call if you need to talk about something, and we can learn about your case. Thanks.